Right, let's begin with the breaking news that has come in from the Bombay High Court. A massive verdict that has come in from the courts. The court has struck down centre's fact-check units. The court has upheld the right to free speech. Fact-check unit has now been struck down by the Bombay High Court. That's the latest that's coming in, saying the centre will not determine what fake news is. The High Court has said the IT rules violate Article 14 and 19. Remember, earlier, the High Court had delivered a split verdict, a historic verdict by the tiebreaker judge is what we're getting to know right now, whatever has been transpiring in the Bombay High Court as far as the centre establishing fact-check units is concerned. So the Bombay High Court now striking down that the government can establish fact-check units and correct what they called false and misleading information about government policies and schemes. Let me go across to my colleague Harish, joining us with more details on this. Harish, what transpired in the Bombay High Court as far as this historic verdict is concerned? This is clearly a massive setback for the centre.
Yes, in fact, remember this matter had gone to the Supreme Court also, and in February, Supreme Court had stayed the fact-check unit notification, and Supreme Court said Centre should have waited for the final Bombay High Court verdict. Remember, the Centre had come to Supreme Court against the interim order of the High Court. Then that day itself, Supreme Court had said you wait for the order of the final judgment of the Bombay High Court. But today it has come. So after a 1:1 verdict, now a clear verdict has come. The tiebreaker judge has ruled against the Centre. In fact, tiebreaker judge Justice A.S. Chandurkar delivered his opinion today after the matter was referred to him following a split verdict earlier. The tiebreaker judge said, "I am of the opinion that the fact-check unit violates Article 14 and Article 19 of the Constitution." Remember, the petitions, including one filed by stand-up comedian Kunal Kamra, had specifically challenged Rule 3, which granted the Centre the authority to form fact-check unit for identifying false online news. The petitions argued that the amendment was ultra-virus of the Constitution, Article 14, Article 19, and remember, on January 31, Justices G.S. Patel and Meena Gokhale had delivered a split verdict on the matter. Justice Patel ruled in favor of the petitioners and struck down Rule 3, setting concerns about the potential for censorship of user content and shifting of responsibility for content accuracy from curators or to intermediaries. He emphasized the need for clear guidelines and criticized the imbalance in addressing grievances related to the government information versus other sensitive issues. So why this issue is important is because the matter has now been finally decided by the tiebreaker judge. Earlier it was a 1:1 judgment. Now it has been it was the row over government fact-checking unit. The Supreme Court had, while take the fact-checking unit, had said it will cause chilling effect on freedom of speech and expression, muzzle speech, dissent against the central government. And the Chief Justice had very clearly said, determination of fake news cannot be in the sole hands of the government and will result in censorship of the press. It will have a chilling effect on the media and should be withdrawn. In fact, this was the Supreme Court observation. But now there were preliminary observations. But now today, as per the tone and tenor, Bombay High Court had also ruled against the fact-checking unit, and this comes as a big setback for the central government.
Right, Harish, thanks very much for joining us at the moment and helping us understand what all transpired in the Bombay High Court today, that massive setback coming in from the Bombay High Court for the centre. On the broadcast, I'm also joined by Dr. Farrukh Khan. He's an advocate. He's a partner at Diwan Advocates. Dr. Khan, good evening. Namaskar. Welcome to Mirror Now. This is a huge verdict by the Bombay High Court. It comes as a massive setback for the centre as well, which was looking to establish fact-check units to what it called counter the false and misinformation about government policies and schemes. Your first reaction, your first thoughts on this verdict?
This is a very welcoming verdict, and when we had an occasion to read two divergent views earlier of the division bench of Justice Gautam Patel and Justice Dr. Neela Gokhale. So at that time, what
Yeah.
Justice Gautam Patel has ruled out, that was fantastic for the free speech, because it was not. See, you have to appreciate this Rule 3, the impugned Rule 3 was technically the court, and now the tiebreaker honorable judge has been also pleased to hold that it was ultra virus to section 79 of IT Act, and it was also not in sync
Hmm.
with Article 14. And the discrimination with regards to online media and print media was something which was not beyond redemption. So it is a very welcoming judgment, and it is for the upholding the right of free speech and freedom of expression.
Dr. Khan, like you mentioned, Article 14 and 19, and for viewers, Article 14 is the right to equality, while Article 19 is the freedom to speech and expression, and that the court said those rules are violative of that. But Dr. Khan, on the other side, this clearly is a setback for the center. But when we see it from the center's point of view, they can argue that this is precisely why we want to have this sort of a fact check unit, because while there is freedom of speech and expression, there's also a responsibility that comes along with it.
See, under the guise of fact check unit, under the guise of any such institution which the government intends to create, it cannot have a license unto itself to create and to kill, the free speech. The problem is that,
Yes.
see, you have to understand the essence of constitutional framework. This fundamental right, Article 14, Article 19, are sanctum sanctorum. It cannot be touched upon. Even the Parliament cannot touch upon these all. These are part of the basic structure. According to Keshwananda Bharati judgment, even the Parliament or the legislature cannot touch these aspects. The problem is that you cannot create a class within a class. So why you want to say that, why you want to cast different rule for the print media and for different rule for the online media? And the penal provisions which were originally encompassed therein, and that was a very slyly approach, rather I would say, was something which would have if it would have been upheld, it would have been a very chilling effect on the right of freedom of speech and expression.
Dr. Khan, Justice Neela Gokhale, that time in January this year, when there was a split verdict around it, had said that such concerns are unfounded, while Justice Gautam Patel had said that there is certainly, a serious concern regarding freedom of speech and expression being curtailed. But how does then one in such a grey area as freedom of speech and expression sort of put it in separate lists as black and white, that this comes under freedom of speech and this doesn't come under freedom of speech then, in terms of the legalities involved?
Yes, so let me tell you one more perspective to this. Even today, the government and the law enforcement agencies are not handicapped to deal with the fake news or the wrong analysis, not analysis rather, but what is being see, we have to appreciate this from a different tangent altogether. What the government, by inserting this Rule 3, had what actually intending to do. The problem is that they would have created a class within a class, meaning thereby that the media, I'm sorry to use this word, the friendly media and non-friendly media. See, the nature of journalism, see, two professions, we advocates and you as a journalist, by nature of your profession, unfortunately, you have to be anti-establishment sometime down the line. Though that does not mean that every time you have to create and you have to say negativity. It's not. But when you are duty bound to question and speak truths to the power, so of course you will publish certain thing, or you will write something, you will broadcast air something which may not go down, too well to the government. So this penal impact, if it was implemented, and if it is made sure that the government has a control as to what will be published, what will not be published, you can appreciate as a seasoned journalist that what would have been the consequences in aftermath thereof.
Sure. Sure, sure. My last question to you, Dr. Farrukh Khan, what is the legal option now available in front of the centre now that it has suffered this major setback from the Bombay High Court? What are the legal options involved now if it wants to take this further?
Yeah, so the government has, as any litigant, government has also option of approaching Supreme Court by filing special leave petition under Article 136. And government, of course, what I think that government, this is a big, loss to the government's credibility. So the government, in my opinion, though I will be happy if I am proven wrong, but the government will definitely challenge this verdict before the Honorable Apex Court.
Hmm. Okay. All right. So that's the legal option that is available to the government. Whether or not it uses that, we'll have to wait and watch. But thank you very much, Dr. Farrukh Khan, for joining us on Mirror Now and helping us understand this entire context of this verdict, this massive verdict that has now come in from the Bombay High Court. With that, let's shift our focus and, in fact, move to what is... All right, we'll keep getting you other updates in this broadcast, but let me recapitulate for you what has happened. There's a massive verdict that has come out of the Bombay High Court just a while back, where the court has struck down the centre's fact-check unit that the centre wanted to establish across departments to fact-check what they called false and misleading information. This decision, remember, is followed by this decision, remember, is preceded, beg your pardon, by a split judgment in January this year, which had happened, which was by a division bench of Justices Gautam Patel and Justice Neela Gokhale. And Justice Patel had said that there is infringement of speech, while Justice Gokhale had said that the concerns of potential bias is in the fact-check units are unfounded. And now, of course, the tie-breaker verdict now coming in. All right, on the broadcast, I'm joined by Manish Tiwari of the Congress Party. Manish Tiwari, good evening. Namaskar. Your first reaction to this massive setback to the centre regarding the fact-check units?
I have not read the Mumbai High Court judgment, but going by what your colleague has told me, if they have held the fact-check unit to be violative of Article 14 and Article 19 of the Constitution of India, I think it's a step in the right direction. Fact-checking can be a very, very slippery slope. You know, whose facts, who's checking, what will you try and control in the name of fact-checking? And so, therefore, it was going to open up a Pandora's box. I would, of course, peruse the judgment. I would go through it carefully. Suffice to say that whatever your colleague has told me, based upon that, it's a welcome step. Hello.
Mr. Tiwari, you've been an information and broadcasting minister yourself as well. Can I also understand from you then, I'm sure that, as the INB minister, there are several sorts of information that come to your ministry, that come to your table as well. How do you deal with and how do you segregate then as to what is fake and what is true? How does the government then deal with it if not a fact-check unit?
Well, we never used to check facts. See, these are all control mechanisms. As I earlier said, whose facts? Your facts could be very different from my facts. If I don't like your facts, can I circumscribe you and censor you? So therefore, it depends upon what your approach is. Our approach to the media was always a very liberal approach. We allowed, dissent, criticism, critique to blossom, often at our own peril and at our own cause. But as the Information and Broadcasting Minister, it was never my remit to try and fact-check and use fact-checking as a surrogate means of censoring stuff which was uncomfortable.
Mr. Tiwari, I absolutely understand where this is coming from and, why this is needed, that the government should not be censoring stuff that makes it uncomfortable. But like you said, what is freedom of speech and expression, what is the kind of information that goes out is very subjective. The government can argue from its place that, these are subjective things, and there is a lot of bias also happening, considering that this is an era of social media. How does then one speak for the government? Where does the government's point of view then be placed? How will it be placed?
The government's point of view is circumscribed by judgments of the Supreme Court going back to 1950, when the First Amendment to the Constitution happened and the reasonable restrictions were put into Article 19. If I remember from the top of my head, there was the celebrated editor, Mr. Upper, and there was this case with regard to the mainstream weekly. And so from then on, the courts have ruled consistently, and this area is absolutely very well mapped out by judicial decisions, and has been distilled. So therefore, all that you need to do is follow the law.
Also, Mr. Tiwari, one of the arguments in this entire case has been given, why does the government need fact-check units when it already has agencies like the Press Information Bureau and the national broadcasters like Doordarshan? But are they well equipped to deal with the kind of, social media times we live in, and the kind of information that keeps coming in, keeps trickling in from all quarters?
Well, I created the new media wing, or what you call the social media wing of the Information Broadcasting Ministry in 2030. All you need to do is to upscale it and see that you have enough credibility that people go to it if they have any doubt with regard to the veracity of a certain news item. Right? So therefore, putting out what is factually correct from, let's say, a government's perspective is very different from fact-checking them. I will put out the facts as I understand them. But am I, or should I be authorized to check your facts as you understand them?
Okay. All right. We'll leave it there. Thank you very much, Mr. Manish Tiwari, for joining us on Mirror Now and sharing your perspective on this massive verdict that has come in from the Bombay High Court. Ladies and gentlemen, the former Union INB minister speaking about, the kind of experiences that the ministry has had, the government has had with information, saying that, of course, this is something that should have been avoided in the first place. But let me quickly tell you what has happened. The Bombay High Court has struck down the establishment of fact-check units by the centre. It has said that it violates Article 14 and 19, that of right to equality and right to freedom of speech and expression. This is, remember, coming in after a January verdict. That was a split verdict this year that came in. And the tiebreaker judgment, in fact, has come in from the Bombay High Court today, which was given by single judge Justice Atul Chandurkar, who said he served as the tiebreaker after that split verdict in January this year. And he has ruled that the amendments violated the fundamental rights enshrined in the Indian Constitution. So this is basically a massive setback, ladies and gentlemen, for the centre, which was meaning to establish fact-check units to counter what it called false and misleading information against its policies and schemes. Now, remember, the petitioners in this case were Editors Guild as well as stand-up comedian and Kunal Kamra. And what they had argued was that this causes chilling effect on the freedom of speech and expression, muzzles speech, dissent against the central government. Determination of fake news cannot be in the sole hands of the government, and it will result in the censorship of the press. It also has a chilling effect on media and should be withdrawn. That's what the petitioners had argued, and that argument has today been upheld by the Bombay High Court. All right, with that, viewers, it's a wrap on this broadcast. Of course, news and updates will continue on Mirror Now, and we'll keep getting you the details of what all has happened in the Bombay High Court. But right now, it's time to wrap this up. Thank you very much for joining us. Bye-bye.